P-A-S-C-A-L. You are now rocking with that dude Pascal. We be going wild, Haitian in the building, so original. Got the haters catching feelings. Get your hands up to the ceiling and keep them held high, cause St. Louis isn't ready. Forget about it, goodbye. Hold on, we just saying hi. Five somebody, rise up weekdays. Catch us live, somebody, let's go.
Good evening. Good morning, everybody, and good afternoon. Welcome to the Pascal Show. Hope you guys are all doing well out there. Hope this show is finding you in good spirits and all that good stuff. Man, we got some things we have got to talk about. We talked about it a little bit, okay? We talked about it a little bit while we were doing the watch party for the Alec Baldwin case and trial, which is also on its way, which is also very, very interesting. But nonetheless, something happened while we were watching and doing that little watch party for the Alec Baldwin case. And I got to be honest, this is pretty wild stuff. I'm not going to lie. This is pretty wild stuff. So we got to talk about it. Okay, this is big. Could be huge for the case and could put a lot of things to rest for a lot of people that are either for or against the freedom and the exoneration of Karen Read. So we got to talk about this. And like I said, it's not going to be a super long show because it's been a very long day already. But I wanted to give you guys at least the broad strokes and talk a little bit about this because I find this to be very interesting. And I still have a lot of questions. I got so many questions. Man. We're going to talk about it. So please do me a favor. Hit that like button down below. Hit that reaction button if you're watching on other channels, on other platforms, of course. That'd be greatly appreciated. Please do not forget to crush that subscribe button. All right? Crush it. Do that if you're watching on YouTube. If you're watching on Facebook and any other place, follow me on my platforms. Facebook, Instagram, TikTok, X/Twitter, all those other places. Show some love, show some support, and subscribe or follow over there. Hit that join button down below, become a member. Think about it. That'd be amazing. Be helpful for the channel, of course. Become a member of the family. And of course, hit that Patreon if you want to check out and support even further. Patreon.com/thepascalshow. It's going right underneath me as we speak, going that way right now. Okay? Okay, we got to talk. We got some things to talk about today, guys. And I got to be honest. When this broke, I was like, man, we're in the middle of watching this Alec Baldwin thing. And I'm like, man, I would have dropped everything and ran in here to give you guys this new update revolving around the case of Karen Read. Now, of course, we all have been following it. If you're a law tuber, if you are a true crimer, it doesn't matter. If you've given any care at all in the true crime or the law tubing world, you know about this case. Of course, the murder trial, okay, of Karen Read. She was tried for taking the life, alleged of taking the life of her boyfriend, John O'Keefe. I'm sorry, I'm trying to pull up a photo, and I had one, and it disappeared. So I'm just trying to pull up another photo. And for some odd reason, it is not being my friend. Hold on. We're gonna get a new one. Bang. All right. So I just want to pull this up. And I mean, this is not the greatest quality photo, but we all know who Karen Read is, okay? Karen Read, we all know who Karen Read is, all right? And just last week, the trial was a mistrial, okay? Hung jury, to be exact. And of course, this moved a lot of people. Everyone was talking about it for the most part. We didn't talk about it on this channel. We talked about the breaking news about it being a hung jury or a mistrial, but that was about it. Right? A lot of other people talked about it for a whole week and then some, of course, bleeding into today. Mostly because of the information that we found out today, which is absolutely insane in my personal opinion. Okay? I still am wrapping my mind around the breaking news that came out today. And I'm still wondering, how in the hell did this happen? Now, I want to remind you really quick that this is all from, well, they're saying it's from an informant. They're saying it's someone connected or one of the jurors in the jury, okay? It's been insane, okay? Just let's be real. I know that there's a lot of people that feel some type of way about the verdict, whether you are on the side of her wanting to find her guilty or wanting to find her not guilty. Doesn't matter. Everyone has had a very specific opinion about this case. Now, I know for me, I was kind of like, I don't know. When you watch the trial, when you hear the evidence, when you hear the arguments on both sides, the defense and the prosecution, yes, you're scratching your head trying to figure out what the hell is going on here. Did she do it? Did she not do it? Now I know everybody and their mama is sitting there going like, oh yeah, corrupt cops, so on and so forth, which it definitely showed that there's some corruption in that Canton PD for sure, and state police as well. Let's not forget, okay? I mean, we are going to be talking about Proctor here in just a little bit because we do have an update about him as well. But like I said, there is still a lot of people that it's like this whole trial is extremely polarizing, right? You're either on one side or on the other. And then the people who are sitting in the middle, like myself, that was just sitting in the middle, just trying to find out the information, trying to see how the trial will kind of unfold. Suddenly people are looking at the people that are sitting on the fence like we're psychotic because we're not picking like a hard side, period, right? Now, the thing is, it has been a very interesting week. A lot of people either are looking at this and going, this is a win for Karen Reed. Because at the end of the day, it shows that some people, the jury, felt some type of way, right? They believed in reasonable doubt or something of that sort, right? But they also felt like, okay, this is an opportunity for the defense to really tighten it up for the next trial. But there's a possibility that there may not be another trial, or she may not look at all three charges in the next trial. Let me explain. Simply by showing you guys this article right here. Okay? This was part of the breaking news. And of course, I myself, I'm very shocked about this. Because, for one, I'm not one who was quickly on the cops are corrupted or there is corruption involved in this case. I was not one of those people that went straight to that. I heard about the case, I heard about the information. I was like, okay, let me hear what they got. Of course, their procedure as far as getting evidence, how they conducted the investigation and all that was very, very bad. Rudimentary, not even rudimentary, less than rudimentary. It was kind of archaic, okay, at best, all right? But there's some things that happen inside the courtroom that I feel like should have been explained, which leads to make me wonder, is there corruption here? Even inside the courthouse? Because how do you mess this up? How does one mess this up? I repeat, how does one mess this up? Judge Canoni, Judge Bev, as some of you guys call her, has some splaining to do. Wouldn't you think? And sorry, my camera's going to be going in and out of focus. I don't know why it's tripping. I need a new lens. But if you really think about it, Why wouldn't she say, it just doesn't make sense, guys. From what I'm gathering, from what I've understood, here it is. The jury could have come to a verdict on all or one or two of the charges. And then they could have just been a hung jury on whatever they were hung up about. So in other words, there was a unanimous decision. Allegedly, that's what they're saying. This is what the defense is claiming now, that the jury did come to them and say, yes, on two of the charges, we were acquitting her. We agreed 12 to 0, that she was not guilty of those particular charges. But there was only one that we could not agree on. That's where it split the room. Other than that, there were two charges that she should have been acquitted on. So somehow the jury came to the understanding or came to the conclusion that if they can't agree on all three charges, then it's a hung jury. Then it's a mistrial. And if these claims are true, this means that she was acquitted on two charges. They just weren't announced in the courtroom when the judge brought the jury in and she read that statement. But instead of her reading that statement, she should have been reading, in regards to this charge, we find her not guilty. In this charge, we find her not guilty. And in the third charge, we could not make a decision, or it's a mistrial, or it's a hung jury on that part. That's what should have happened. Allegedly. Again, this is what the defense, Karen Reed's team, is claiming. So, in other words, what's up with the judge? Because the judge should know that, right? The judge should know that. In fact, Cindy Fisher just said this. They did not tell the judge. Now, if that's the case, okay. But wouldn't she want to go in and go, okay, are you guys not fully decided on all? Are you guys split on all three charges? Or are you just split on one? Where are you guys split at? I mean, I feel like that's okay, right? To check in with the jury and just see where they are as far as the verdict goes. You're not manipulating the decision. You're not manipulating the verdict, but at least trying to figure out where they stand. But it seems as if the jury didn't understand the game, the rules of the game, the rules of the decision, it seems like. Right? It seems odd. But now for me, I'm like, I would love to see the paperwork. If there was paperwork that shows them actually voting unanimously on two of these charges. Because that is a very strong claim. You got to remember, though, too, and we got to hop back and forth on this. We got to hop back and forth over this fence, okay? But you got to remember, there's a lot of people out here that feel some type of way about this case. Like I said, split straight down the middle. Like we've talked about this many, many a times on this show, on this channel. And literally, how you guys talk, it splits right down the middle. It has always been different, or it's always been split, okay? So when it comes to this, I can see, and of course, there's a lot of very passionate people on both sides of the aisle in regards to this case. So I am kind of interested as to why, we're getting this information. We got this new information about, it was two charges that she should have been acquitted on. Are we absolutely sure that is fact? Like I said, we're hopping back and forth on the fence, man. We're hopping back and forth. Do we know that for sure? without a shadow of a doubt that this information is 110% real? You got to remember, there's a lot of people that want her to be exonerated. There's a lot of people that want her to walk and be found not guilty, which is understandable. And then it's understandable that the people that are on the other side that say they want justice for John O'Keefe and think that she had a hand at taking his life, I get that they want that justice as well. But it's interesting. It's just interesting, right? About all this stuff. So let's take a look at this. And like I said, they're getting the information and I'm going, okay, where's the actual hard facts, the hard evidence, right? That's just me, that's just me asking questions, right? Because that is something that's very interesting for them to sit there and say 12 to zip on two of the charges. But then there's the other one that they just couldn't agree on. It's very interesting to me. So let's take a look at this. Okay. They seek to dismiss two charges, reveal how jury may have voted in trial. Okay. So, whoops. Karen Reed's defense attorneys, Jackson and Yannetti, claim in a new court filing that the jury in the high-profile Massachusetts murder trial was in unanimous agreement on two of the charges. The filing was made in an effort to dismiss some of the charges against Reed. Reed is accused of hitting and taking the life of Boston police officer John O'Keefe, who she was dating at the time, with her SUV and leaving him to die in the snow, which we already know. Her defense attorneys say she's being framed and O'Keefe was unalived during a fight, then dragged outside and left on the front lawn of the Canton home. Okay. Now we already know about this, that this was a very long trial. Okay. Months-long trial. Yes, it was. They obviously, in the court of public opinion, it was split down the middle. Everyone had their own personal opinions about this. And I understand that too. I get it. 110%. You're entitled to your opinion. Okay. And don't let anybody tell you different. All right. We can agree to disagree in a diplomatic and mature fashion, I believe. Okay, so of course, this trial, which gained national attention, ended last week in a mistrial due to a starkly divided hung jury. So, how did the trial jury vote? Okay, so Reed's attorney filed a motion to dismiss on Monday. In the motion, Jackson says a juror contacted him the day after the mistrial was declared. According to Jackson, the jury unanimously agreed that Reed should be found not guilty of second-degree M, as well as leaving the scene of a personal injury and death. So, unanimously agreed that she should be found not guilty of second-degree M and leaving the scene of personal injury and death. Pretty big ones. Jackson did not reveal what the jury voted on the charge of manslaughter while operating under the influence. So apparently they were split, or there was some sort of dissonance in regards to the manslaughter charge. Okay? But the other two, they said that she wasn't, allegedly they say she wasn't guilty of second degree M or leaving the scene of personal injury and demise. Very interesting, right? The defense attorney said Judge Canoni, or Judge Bev, some of you guys call her Judge Bev, did not provide Reed's lawyers the opportunity to be heard when the jury indicted them and indicated for a final time that it was an impasse. He also said in the new court filing that Canoni did not ask the jury foreperson what counts the jury was at an impasse on. See now, so I can see, like I said, I can totally see why, okay? I can see why Reed's attorney might be looking at this and going, hey, wait a second. Did the judge even ask just to see where they were at in their decision? They kept coming back and there's obviously some sort of tension and there's obviously a divide. They're saying that there's a divide and it's kind of like, well, where's the divide at? Because she could have walked out and been acquitted on 1, 2, or all 3. We could have found out about these 2 during the time the verdict or the decision was made to say that this was a mistrial. It's very weird, guys. It's very weird. Because at the end of the day, this could be a line of miscommunication, simple miscommunication, but then there's another world. There's another side of the world that looks at this and goes, wait, this is corruption 101. Once again, we're seeing that the law is being corrupt once again. Interesting, right? Try that. Interesting, right? And so, of course, it makes you wonder, what's really going on here? Because I feel that, I feel like Cannoni should have checked in with the jury. I don't think there's anything wrong with that. But now, because if she was indeed found not guilty on 2 of these charges, that means she can't be tried for those 2 anymore. This is when double jeopardy comes into play. She can't be tried for those 2. They can't do a retrial. But the thing is I want to see the paperwork, right? We want to see the proof, right? But see, now here's the thing. If the claims are true and there were 2 counts where she was found not guilty in, they can't retry her for those things. At least this is what the defense is claiming right now. This is what they're putting out. If this verdict exists and they said count 1 and 3, she was acquitted for, she should not be going through the whole situation. Okay? She cannot be going through the whole situation all over again. She was acquitted for those. But the second one, right, which is the under the influence, okay, charge of manslaughter while operating under the influence, she could still be tried for that. That's if this is 110% true, okay? Because like I said, you're getting a juror calling you and saying, we did this and this. I want to see the proof. I'm sorry, guys. I'm sorry. You know that, just because it's being said by somebody doesn't mean that it's automatically 110% true. You got to remember, there are people in that jury, I'm sure, that were 110% so passionate about her guilt or her innocence that what if they were willing to say whatever they could to the defense? I know that sounds crazy, but crazier things have happened. Okay? But the defense, it has filed to say, hey, she should be acquitted on these 2. At least these 2, right? But I want to see the proof, without a doubt. So, had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and 3. Ms. Reed was denied her right to receive those verdicts in her favor. This is what Jackson wrote. Didn't he say there's no quitting him? There's no quitting us. Why can't I quit you? He ain't quitting. He clearly isn't. Okay? So, Yannetti said he was contacted by 2 informants who received information from 2 separate jurors. Yannetti said one of the informants provided screenshots with the juror who said, "I thought the prosecution didn't prove the case. No one thought she hit him on purpose," which is big, if it is true. Yannetti claimed that she also spoke to a person who joined a Zoom meeting with a third juror who they work with. That person claimed that the juror said during the meeting that polling for the manslaughter began when with an even split and ended deadlocked with 8 people voting guilty and 4 people not guilty. And I agree. If this is all just hearsay, then it's hearsay, right? If it's all just hearsay, then it's hearsay. Okay? But let's continue on. In the motion, defense attorneys argue Reed should not face a second trial on 2 of the counts because of double jeopardy. Bang, bang, bang. She should not be getting the 2 counts because of the double jeopardy. Yes, okay? If she was found not guilty, and if that's really true, then she needs to be let go of those things. And the only thing she should be seeing a retrial for is for the involuntary manslaughter under the influence. No deciding jurors have publicly commented on the trial. One alternate juror spoke to this news station about what it was like being a part of the trial. Didn't I tell you that there was going to be jurors? Okay. Coming out and talking about things. I guarantee you a book's coming out. Watch. When will her new trial date be decided? Well, apparently they're supposed to have a new trial date on the 22nd of July. Okay. On the 22nd of July. That's when they're supposed to be dropping it like it's hot. And Karen's supposed to be in there making an appearance, and they're going to make a decision on whether or not there is going to be a real retrial on this case or not. But I'm telling you right now, if this is true, if this is 110% true, she should not be tried for those 2 counts. If the jury really did find her not guilty on count 1 and 3, she should not be seeing the inside of a courtroom for those 2 charges. And hey, this is me, a guy who sits on the fence, right? I don't know where I stand on it. All I say and all I believe is if the jury went in there, listened to both sides, and they felt that, hey, the defense had a stronger case, there was a lot of reasonable doubt in there due to showing the corruption of 5-0 and all of that stuff. And they made that decision unanimously, 12-0, that on count 1 and count 3, she was found not guilty, so be it. So be it. Then she should not be tried for those ever again. She has been acquitted on those. But at the same time, then I look at the court and I wonder why that mess up happened. That is a huge fumble. Do you understand? That's a huge fumble. And here's the thing. This could be, and we have to say this, okay? It could very well be an honest mistake. Okay, I'm sorry. I don't mean to laugh, but it could very well be an honest mistake. But in my mind, I'm like, it's the court. You should know how the court runs if you're a judge or even a lawyer, right? So you're the judge. You're telling the jury what they should and shouldn't listen to, how they should conduct things, how they should come to a decision as far as this verdict. And then suddenly you drop the ball and forget that they don't have to be fully, that it doesn't have to be all 3 down the line, 12-0, that it could literally be, they can agree on even 1 of the charges, and the 2 could be hung jury. That part was never explained. That part doesn't make sense to me, guys. Like I said, The court, what's up with the court? And that's what I'm saying. It could be a mistake. But then there's going to be another side of the world that's looking at this and going, corruption, absolute corruption. See? The defense was showing how corrupt the system is in this area, in this state. And now we're seeing it again. Because that information, those verdicts should have been read. And the fact that they weren't read, if that is true, if those verdicts are true, have mercy. How many trials has this judge judged at? Think about it. How many trials? So why this one of all trials? It turns into a full mistrial on all three. That's what was told to the public. You feel me? That's crazy, guys. So do we look at that as, okay, it's a little misunderstanding, you know? They just didn't know. Huh? You're the judge. You know you're the referee of this game. You should know this game backwards and forwards. If you need to throw a red card, you throw a red. You need to throw yellow, you throw yellow. If there's a foul, there's a foul. If it's a touchdown, it's a touchdown. I know I just did like 3 different sports in one thing, but you know what I mean. Make that make sense. Make that make sense. But again, this all rests on if this is 110% true. Okay? Because again, all we're hearing is the hearsay. We're just hearing the hearsay all day long. Okay? That's all we're hearing. But I just want to show you guys a little bit, like, the documents are here. I do have some of the documents. All right? Their motion to dismiss, as you see right here as I blow it up. Look, Ganda. It's very interesting. We're not going to read all of it, okay? But we're going to look at a little bit of this, okay? We're going to skim through this mug. All right? But like I said, that's crazy. They go through a month-long trial. They go through all of this work. Then when it comes to the time where the jury has to make a decision, they have reached unanimous decisions on 2 of the counts, but they didn't come to a unanimous decision on 1. And that blew everything out the water. So again, it's very, okay. I will say this. If they decided to do this, right? They obviously made this motion to dismiss, okay, for 2 of the counts. The fact that they did this, they must really believe that what they heard from their informant and from that juror is absolutely 110% true. But like I said, if I were them, if I were a lawyer, okay, for the Karen Reed trial, I would want to make sure I have everything, like a carbon copy of proof of the unanimous decision on those 2 counts. Because again, to me, this shows potential corruption. But then again, I don't know. It's so crazy to me. Like I said, I'm not sitting here going, everything's corrupt, it's all wrong. But then who makes a misunderstanding? Who makes a big mistake like this? How does that happen? It just doesn't happen, guys. It just doesn't. It just doesn't. So it's frustrating because it's like for somebody who sits on the fence and the whole trial on the defense is showing proof positive of how corrupt, how messed up, how jacked up police department was. And then to add not even the cherry, but the sprinkles on top to this really messed up Sunday. The judge doesn't even think to see what the verdict is on individual counts that they were looking at. That's very weird, guys. Now, that could be corruption. That could be a mistake. I don't know. I leave that up to you guys. Like I said, I look at that and I go, it's the worst situation because you got people looking at how corrupt the system is out there. And then the system does this. Like I said, if it's true, this is very damning. And Judge Bev, Judge Cannone, has a lot of splaining to do. But let's look at this real quick. We're going to breeze through this real quick. Okay, but this is the defendant, Karen Reed's motion to dismiss. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court, pursuant to the 5th, 6th, and 14th Amendments to the U.S. Constitution and article of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3 currently pending against her on the grounds that the jury reached a unanimous decision to acquit her on those charges, and ultimately because there was no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Miss Reed was not guilty, and that therefore a retrial on such counts would violate the double jeopardy protections of both federal and state constitutions. And again, if this information is absolutely true, they have absolutely right. They're absolutely right to have a motion to dismiss. If she was found not guilty on those 2 counts, they should be giving her that and let her be acquitted of those charges and let her fight for the involuntary manslaughter under the influence and call it a mother-loving day. That's what should be happening. The ancient right in the retrial, okay? In the ancient right to a jury trial is mere procedural formality, but rather a fundamental reservation of power to the American people. Moving on, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the 5th and 6th Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among these, among the reasons colonists cited, okay, we're going to move on from that. It follows that a jury acquittal is entitled to the utmost respect of our criminal justice system. The double jeopardy clause provides that no person shall, quote unquote, be subject for the same offense to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, or compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy has been that a verdict of acquittal could be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. So in other words, she should not be retried for these things at all. I mean, it's interesting because they're just quoting legal jargon. It's like, okay, she should not be tried twice for these things because she has been acquitted according to what we have heard from this juror. There were 2 counts that she was acquitted on. You guys should be letting her go on those things and let us fight for the involuntary manslaughter and call it a doggone day. But here are some quotes from multiple legal documents and books that we've read showing proof positive that there should not be another trial for Miss Karen Reed. That's basically all it is. Okay. Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating That's very interesting. Jurors indicating in no uncertain terms that the jury had a firm 12-0 agreement that she was not guilty of 2 of the 3 charges against her, including the charge of M in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes reprosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternately, to the extent the court believes the further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant on 2 of the 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. Now, here it is. All right. I don't know how they're going to do that. Okay? Let's be real. How are they going to do that? Okay? If it's like, hey, we want to get all the jurors back together, okay, and they're going to relive it again. We're going to talk about all this stuff, and we're going to get the information from them. Will that work? Will that be helpful? I don't know. I honestly do not know. So for them to be like, yeah, bring them all back. Hey, guys, let's run it back really quick. I don't know about that. That's just my personal opinion. Because again, wouldn't that require the judge to go out and like seek the jury to come back? I don't think that's going to happen. I really don't. But wilder things have happened. Okay. Let's see. Background. We already know this. Let's go on. Okay. So the following day, on July 2nd, Attorney Jackson was contacted by a juror in this manner, Juror A, who stated that they wished to inform him of the true results of the jury deliberations. See, now that, according to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, second degree M. Juror A was emphatic that count second degree M was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. Interesting. The jury also unanimously agreed that Karen Reed was not guilty of count 3, leaving the scene with injury or death. Another day later, July 3rd, Yannetti was contacted by 2 different individuals, informant B and C, who had received information from 2 distinct jurors. Now, see, this is the thing. This is where I hear this is just an informant and this is just hearsay. See what I'm saying? This is kind of fluffy, okay? This is kind of faulty because it's not from the horse's mouth. It's like the game of telephone. But let's hear what they have to say. Informant B and C, who received information from 2 distinct jurors, B and C, both of whom were part of the deliberating jury in the case. So the informant sent Attorney Yannetti a screenshot they had received from someone. So of text messages that intermediary B, I guess hereafter intermediary B, so that this person had received from Juror B. In that screenshot, Juror B text the following to this particular person. It was not guilty on the second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Informant C had been in contact with another individual, another person, another informant, I guess. Who is a coworker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of their text messages with the intermediary C regarding what Juror C revealed in the Zoom meeting. Again, this is hearsay, though. So this person sent to the informant, this is a screenshot that they said in a text message. No consideration for murder 2, manslaughter. Manslaughter started polling at 6-6, then deadlocked at 4 no, 8 yes. 4 not guilty, 8 yes guilty. Interesting, right? Let's move on. Informant C. Interesting. I just said interesting, but they said interesting. If it's no consideration for murder 2, shouldn't she have been acquitted on that account? Hung on the remaining charges. Goes back to the jury verdict slip. That was all confusing. Now remember, there was a lot of speculation, a lot of rumors bouncing back and forth saying that there was one person that was holding on, right? There was only one person that was holding on, that was refusing to change their mind and all that stuff, which was causing a hung jury. And that doesn't sound like that was the case at all. Even so, that part, I believe, is that part what we heard in the from the judge when she read the decision, like the letter or the statement made by the foreman or the foreperson. They literally were saying, some of us aren't stuck. We're kind of deadlocked on this thing, and some of us are just not willing to budge. And it was some, not one. It said some. So that makes sense. The rumor out there was saying that there was only one person holding on for dear life, but that's not the case here. Moving on. Intermediary C says she should have been acquitted. I agree. Yes. The remaining charges were what they were hung on. And the instruction paper was very confusing. Interesting. So they're saying, paperwork was very confusing. They couldn't figure out what it all meant. So when they read through it, maybe they read it as if it was like, okay, it sounds like they want us to be fully unanimous on all 3 counts. So I guess that's what's going to be. And if we can't be unanimous, like all the way through the whole thing, then it's a hung jury. Maybe that's what happened. But I feel like if there was confusion, I feel like they could have asked the judge. But maybe not. So, again, this is a very, very interesting piece of information. Okay, I can't read the whole thing right now tonight, but I did want to share with you guys a little bit of this because that's crazy. And again, if this is true, you got to remember this is such a big trial, such a big trial. There's so many people that feel one way or the other. I can see people making things up, posing as someone or acting as someone for their own reason. Just throw things off or make things sway in their favor because they do feel like this person is not guilty. That's a possibility here. But I don't know. it's enough for the lawyers for Karen Reed. It's enough for them to believe. It's enough for them to believe. And it's beyond just hearsay, which is very interesting in my personal opinion. And then I also wonder, what is the form? What does the form look like? That was making the decisions. What they were using for the verdict. What does the documents look like? What does that paperwork look like? What is it? What is it on the paperwork that would make them feel confused, potentially confused? I'm curious, but I feel like that's something that they would be like, yeah, we got to go back in there and ask some questions. I mean, wouldn't you think? But maybe not. Hold on, guys. Let me play.
We are following major breaking news right now in the Karen Reed mistrial. Her defense team just moments ago filing a motion to dismiss 2 of the 3 counts against her, including the charge of second-degree murder and leaving the scene of a deadly crash. So her trial ended last Monday in a mistrial. We reported on it extensively, right? A jury could not reach a unanimous verdict on all 3 counts, but according to the court documents filed today, her lawyers now say they have since heard from 3 jurors that the jury did, in fact, have a unanimous decision to acquit her on those 2 counts. In the filing, they say a retrial on those counts would violate double jeopardy protections. Again, Karen Reed's lawyers just moments ago filing a motion to dismiss 2 of the 3 counts against her, including that most serious count of second-degree murder. We're going to bring you any updates as they come in, but certainly this is massive news happening today in the Karen Reed trial. Now, all of this news is coming down on the same day that the lead investigator in that case could learn his fate.
Wah, wah. Now, we're going to get into Proctor here in just a second, okay? But this is very, like I said, the fact that the defense is filing this information or filing this motion to dismiss 2 of the charges and all that, I really want to see what happens next. What is the court going to do? What is Judge Cannone going to do, right? What's Judge Bev going to do in this situation? Because let's be real, she's the one who actually knows, I'm assuming, would have some semblance or some idea of what the verdict really truly is. Now, if these claims are actually true, wow, this shows potential corruption for real. Then again, if this, some of this that we're looking at is based off of hearsay, screenshots that could be doctored, so on and so forth. I mean, think about that for a second. There's people out here that'll be willing to do anything to get her free, to exonerate her, move the goalpost just a little bit. You know what I mean? But like I said, I'm just sitting on the fence and I'm just putting out the possibilities on both sides, right? Because we got to keep it somewhat fair.
Thanks for being with us, everyone. I'm Melody Mendez. So let's talk about Trooper Michael Proctor for a moment. He was relieved of his duty. He is now the subject of an internal investigation.
Michael Proctor is trash. I think we can all agree on that at this point now. Okay? He's a very, very bad guy. All right? And I'm sure he's more corrupt than we ever can even fathom. All right. I think it's beyond just a few text messages and so on and so forth. I think this is a very, very dirty cop. Okay. And what's coming to him is coming to him. Let's take a look.
By Mass State Police. In fact, that investigation began before the trial even started. But now there's a hearing getting underway any minute now about what happens next. So NBC 10's Minash Kungwari live in Framingham. Minash, what can we expect from this hearing today?
Well, we know that it means that Trooper Michael Proctor will have one more time to defend his actions before his superiors here at the department ultimately determine his future. Now, this whole thing is really centered on inappropriate texts he sent while he was serving as lead investigator on that murder case. Those texts came to light during the Karen Reed murder trial. And in fact, in some of those texts, we saw that he was talking to family, friends, and colleagues, referring to Karen Reed as a, quote, whack job. And one text to his sister, Proctor, said, quote, hopefully she, meaning Karen Reed, kills herself.
I think I've been very clear, and I want to remain very clear. Misconduct in any way, shape, or form of the Massachusetts State Police will not be tolerated. I think I've said that I condemn those comments in the strongest terms possible. They are not reflective of the Massachusetts State Police. That's not where we want to be as an organization.
Well, after being relieved of his duties last week, Proctor was transferred from the Norfolk County District Attorney's Office to Troop H at the Mass State Police Department. He is currently getting paid, but is not actively working. His car, gun, and gear have been taken away, which is standard practice. After today, one of these four things on your screen could happen. He could either be retained on full duty, placed on restricted duty, suspended with pay, or suspended without pay. Now, I can tell you that the hearing is beginning right now. It should have started just a couple minutes ago.
I mean, this, of course, is earlier today, but yeah. But it's interesting because there's possible outcomes, and what's going to actually happen, I have a feeling, because I don't know what the I have not seen the outcome as of late. Actually, hold on. I think I do have something here. Hold on. Let's see. There it is. Oh, come on. Let's try that. Just a little update with Proctor here. Okay. Lead investigator in Karen Reed case suspended without pay. Okay. He's been relieved of his duty and his police issued cruiser, his gun, and gear taken away following standard practice in such cases, but was still collecting a paycheck pending the hearing. But not anymore. Now he a broke soon to be ex-cop, because he's suspended. He's suspended without pay. It's not like they said, we'll let you resign. No, he's suspended without pay. So we'll see what happens with that, right? We'll see what the outcome of that is, right? Yeah, just Debbie. That's the problem, right? There's a lot of reasonable doubt surrounding the case, and then on top of that, you have corruption within law enforcement as well. I mean, it's bad, right? It's bad. So if you wrap all those things up, yeah, you're going to have a divided room. You're going to have a divided court of public opinion, because it's like, okay, well, they're corrupt, but then at the same time, the situation with Karen is this way, and you know what I mean? To the text messages, the voicemails, the information that we've heard about, the relationship and blah 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 blah, right? It's a tough one, guys. Like I said, that's the reason why I can't sit on one side or the other side, like either side of the fence. That's why I'm straddling this one, because it's almost like a trifecta of like the perfect storm of really bad, corrupted crap all in one situation. And then, yes, it's confusing so many different people, right? But then, people will make decisions off of emotion, or they'll make decisions off of heart, right? And so they'll be gung-ho and passionate behind one side or the other because of how they feel. But in this situation, a lot of the hard facts were dismal at best. It's interesting, guys. It's very weird. But let me play a little bit of this other video too. It's a news clip. Just talking about the breaking news about this dismissal, this motion to dismiss.
Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Santa Fe, New Mexico, covering the Alec Baldwin case. But we want to switch gears momentarily here for some breaking news out of New England in the state of Massachusetts in the case of Karen Reed, the one we just finished up here on Court TV. The defense has filed a motion asking for 2 of the top charges against Karen Reed to be thrown out. And the reason they are asking it in this motion that they filed is because it has come to their attention that the jury had a firm 12-0 agreement that Reed was not guilty of 2 of the 3 charges against her, including that top charge of second-degree murder. According to Alan Jackson and David Yannetti, the lawyers, of course, representing Karen Reed, who filed this motion, they say that jurors got a hold of them after hearing reports about the supposed juror split. We've heard all kinds of things. If you've been on social media, people are saying, oh, it was, 6-6, or it was this, that. They're saying that jurors reached out to them and that the jury had unanimous verdicts of 12-0 on the top 2 charges. But apparently what I'm reading here is they didn't put it together that they could have come back with those verdicts and said not guilty, and hung on that 3rd count. Let's bring in Jessica Ehrlich to discuss this. This is interesting, Jessica, because, we got the jury coming into the courtroom saying we are undecided. We can't come to a unanimous decision if this is true. Does the defense have a solid motion here to basically dismiss these charges? Because if indeed the jury was in agreement 12-0, they effectively came to a verdict on those top 2 charges.
Yes, I mean, I'm dying to get my hands on their motion because I would really like to see, from a legal analysis standpoint, if there are precedents in the state of Massachusetts that they're able to cite to in this matter. I mean, it's certainly from a public policy standpoint, we know that for all courts across the country, you always want to have, especially after a lengthy trial like this, and it's been to the jury, it behooves everyone, and it is sort of the public policy standpoint, that you want the jury to at least come back on 1 or 2 of the issues, to avoid a mistrial. You really want to do everything you can to avoid the situation that we had here when they had a hung jury. So I definitely think from that standpoint, it's a very strong argument to make. The question is, in terms of Massachusetts, will the judge be able to call the jury back and feel that they're able to take this vote given everything that's happened since they were dismissed? So it will be very interesting to see. I mean, definitely quite a turn of events here. I mean, we've been following this for a long time, as you know, and it is fascinating, and actually does not surprise me at all that the jury did have very strong opinions about those first 2. And you and I were talking when remember, there were so many issues with the jury instructions in this case that we knew that something was going to happen for sure. I mean, this was just very confusing for the jury. They had to redo the forms. So really, I'm not surprised that the jury came back on this. And it's very interesting that the jury actually reached out to the defense on this. I'm also curious as to how that transpired and what was going on there.
That's what I'd like to know too. Like I said, suddenly 1 minute you're hearing the hung jury, and then all of a sudden, out of nowhere, you're getting contacted by jurors or by people that are claiming to be jurors. And like I said, I guess a part of me kind of wonders how much of it is actually true. A few screenshots and all that. I mean, yes, these are allegations for sure. So I want to know, what's the judge going to do next? What's the judge going to do? Is she going to bring them back in and get a verdict? or not. But again, it's just interesting how you get this information. Suddenly the jurors are reaching out to the actual lawyers themselves and saying, hey, no, that's not actually what went down. What this decision really was this, and this. And then the screenshots and all that. Like I said, it's very interesting. I'm going to play a little bit more of this.
That conversation was had.
And there has been so much misinformation because of the interest levels and the different bloggers that have jumped into this full force. It'd be, in terms of a remedy here, if the court really wants to find out, you don't just go by what the defense says, obviously, and you can't really just go by with what 1, 2, 3, or 4 of the jurors told the defense.
You're absolutely right. I agree with this. You can't just go on what one and then 2 other ones that were coming through another source. It wasn't even coming straight from a juror's mouth. It's coming from another source. I mean, I'm just saying you can't just rely all on that, on just one. You can't just rely on one thing, right? And you see what I'm saying? And then, of course, this is when people start to side-eye the defense because they start wondering, are they moving the goalpost because they want to move the goalpost? Or are they adding to the idea of corruption within this, within the system and all that stuff again? Or did jurors really reach out to them and tell them what's up? And like I said, I think that there's going to be both sides of the fence, people asking a lot of questions. Okay. But let's continue on.
Great. Juror number 4 believes that it was 12-0. Don't you have to? Doesn't the court have to do a full investigation and contact all 12 of those sitting jurors to validate this claim from the defense and then make a decision after establishing that this is in fact true?
Well, it'll be interesting to see how they, wrote their argument. I think certainly the judge would speak with the foreman because really the foreman is supposed to be the spokesperson for the entire jury. So if the judge speaks to the foreman, if they even go that far, I mean, I don't know that it's really a matter of saying, is what the defense saying true? It's also a procedural thing. Can they even bring the jury back after they've been dismissed?
That's another question too. Two things that this lady just posted or just posed that I think are very good questions. One, can we reach out to the foreman or to the foreperson and find out what the jury's foreperson has to say about this? Will they sit there and say, yeah, it was unanimous on 2, but not unanimous on 1 of the charges? I'm just curious. Then also on top of that, what does she do? What does the juror do? Have them all come back? Have all the jurors come back to sit down and talk about their verdict again? A lot of these people are gone. They want to go back to their normal lives. They want to go back to work. They want to be with their family, friends. They want to go back to life. They've been locked up for doggone over a month, right? So how does one do that properly? It's like, guys, I need you all to come back. I need you all to come back really quick so we could talk about this verdict on the 2 charges. Did you guys vote not unanimously not guilty? I mean, and then also, what does that say about how does that look on the judge as well? That looks terrible too, y'all. That looks terrible too. Mimi, thank you so much for the support. I really do appreciate it. Thank you for the super sticker. I'm just saying that's weird, right? Savannah May, thank you so much for being a member for the past 13 months. Oh my gosh. Thank you so much. 3 streams in one day. Thank you for all the work you do for us. Prayers to you and your family. Thank you so much. I really do appreciate it. Thank you so much. I really do appreciate the support. So like I said, it just seems a bit weird. All right. Seems a bit weird the information that's being put out here. I'm not sitting here saying an admission of guilt. I'm not saying that she's guilty. I'm not saying that she's innocent. But the fact that we're hearing information from jurors that are reaching out, and like I said, we're hearing it from people who are claiming to be jurors. We live in a wild time, guys, where things can be doctored, things can be manufactured, things can be manipulated to look or sound like something that it's not. I'm not sitting here saying that Karen Reed's team is lying. I'm not saying that at all. But I am quite curious as to how they're going to be able to prove this solidly. Because you got one juror that reached out directly. Everything else has been through a source. It's been hearsay, basically. It's very interesting. Okay? I think it's very, very interesting. And I just don't see, but if this is true, it blows my mind that a court would mess up this royally. That is wild. Like I said, if it's true, it is wild. And then if it's true, the judge has a lot of explaining to do because she let 2 verdicts just slip through. So they're going to have to redo everything all over again. I don't know. That's so wild, guys. Crazy to me, guys. Absolutely crazy. I know a lot of y'all feel some type of way about this, right? Some of you guys are like, yo, she is guilty. She is guilty. She is guilty. And a lot of y'all are like, she's innocent. She's innocent. She's innocent. And I say, this one's a tough one. Because like I said, a lot of evidence in there is very thought-provoking for both sides, for both the not guilty and for the guilty. The other piece, though, because I do feel like it, I always err on trying to be fair, right? If those jurors did indeed find her not guilty, if they indeed found her not guilty on those 2 counts, then she should not be tried for those 2 counts. But I want to see the Carfax. Show me the Carfax. Show me the facts. Show me the hard evidence that shows me without a shadow of a doubt that the jury did come back from deliberations with 2 counts being not guilty and 1 count was hung. That's all I ask. And I'm sure that's what Karen Reed would like as well. Anyway, guys, that is the show. I appreciate you guys coming in and being a part of the conversation. Okay, because I know this case has been very polarizing. A lot of y'all have been feeling some type of way about it. But I do appreciate you guys being adult. Okay? Being adults. Agreeing to disagree, but still being able to put in your thoughts in the chat. I do appreciate it. Because I know it's hard out here to put in thoughts, put in opinions, and all that. Okay? But I do appreciate you guys. So please, guys, do me a favor, hit that like button down below, crush it, make it scream out your name. You know what to do. If you're watching on Facebook, please hit that reaction button. That'll be greatly appreciated. If you're watching on other platforms, please be sure to hit that follow button on X/Twitter, Facebook, TikTok, Instagram. Follow me on all those platforms. Do not forget to crush that subscribe button on this main channel on YouTube. Please go over to my secondary channel on YouTube as well. It's called The Pascal Show Clips. Go crush that subscribe button over there. We got some really great content coming up this week for you guys over there. So please show some love if you can. That'd be greatly appreciated. Don't forget to subscribe. Also hit that join button down below. Become a member, okay? Become a member of the family. Also, if you want to support the channel even more, go to patreon.com/The Pascal Show. It's underneath me right now, going that way as we speak. Go check it out. Show some love, and I will see you guys tomorrow. Okay? Much love to you guys. Have a great rest of your night. Sleep well, and I'll see you guys tomorrow. Be good to yourselves. Be good to one another. See you guys soon. This is the Pascal Show. Bye.